Hello, welcome to our podcast, First Rate Law. My name is Bobby Raitt, and with my partner and co-host, Tom James, we're going to talk to you today about a very interesting topic. We get this question at the beginning of most cases from most clients, and that is, how are you guys paid? You know, the general public, and Tom and I talk about this all the time, they generally think I'm going to have to pay money up front, I'm going to be billed, or I'm going to get something that says you owe X before we can go forward. If we rolled like that, I don't think we would have many clients, Tom. I don't think, the average person can afford that kind of thing. That's why when you do get into an hourly rate with your attorney, you're generally a corporation or a company or a very wealthy person that has that type of corporate attorney. We're personal injury attorneys. And Tom's going to explain the details, but we work on what's called a contingency fee. It's contingent on you getting something. You don't get anything, we don't get anything. So, Tom, explain a little bit about how we do that and why we do that.
Yeah. So, I mean, the why is probably the most important thing. So why do we offer this fee arrangement or this payment arrangement of contingency fee? It's because it opens access to justice, right? It opens the ability for people to have a claim and to get some recovery when they're injured. If everyone had to go cut a $10,000 check and give it to their attorney as a retainer, then there would be very few lawsuits out there, because who has $10,000 laying around to throw down as a retainer other than, if you're a very large corporation or insurance company. So contingency fee basis is the way, it's the great equalizer, right? It equalizes people to these large corporations that have tons of money, because now you could come in and you can talk to us, right? Obviously, we give free consultations no matter what. So, if you have any questions, if you have any concerns, you give us a ring. Hey, here's my situation. Is this something that could turn into a case? That is easy, right? Give us a call. But once it turns into that situation where we're like, hey, look, you need to come in and talk to us about this. We need some more details to get into let's get into the weeds of the situation, whether it's a car crash, right? Slip and fall, construction accident. And then once you get in, we start describing the actual way that this works. And so, as Bobby mentioned, contingency fee basis. The contingent means we only get paid if you get paid. So when you see TV advertisers saying that same thing, like it's something special, hey, we're not going to charge you unless we get recovery for you. Well, we all do the same thing. It's not special.
The no fee guarantee. The
Right.
no
No
fee
fee
guarantee.
guarantee. I love that tagline though. I mean, it's a great tagline and it really sticks in your mind, but it applies to most every personal injury attorney that you're ever going to meet. There are some that want you to pay the costs and expenses up front. So they want a couple $1,000s up front so they can pay the court filing fees and that type of stuff. We do not do that. We don't take any money from anyone up front. We will take the risk of whether or not your situation turns into a case. And that's very important. Again, we have to open up and make sure that everyone has access to justice. So anyway, our standard fee arrangement is that we take 1/3 of the recovery after litigation costs are taken into account. And so, just to give you some details, what are litigation costs? Well, it's like $235 just to file a lawsuit. Every time we order a medical record from whether it's Corewell or whether it's St. John's or Ascension, they charge us per page. So, all of those things add up. And so, whenever we get recovery for somebody, the first thing that comes off are those litigation costs. That leaves a net number, right? Net after costs. That's when our 1/3 attorney fee is charged. Now, here's the great thing about that. We take our 1/3 after the costs. So you know that we're not just spending money willy-nilly, hiring experts for no reason, because it affects our fee as well as it affects your recovery. From there, again, settlement, litigation costs, attorney fee is taken out. That leaves a net number. From that net number is when any liens would get paid or any medical expenses. If medical expenses are part of the case, those types of things are all taken care of. And liens come from health insurance companies and things like that. So whatever's left over there, or the amount that's left over, is your recovery. And that's a pretty standard way of doing it. I'm not aware of many other firms who do it differently.
Although I think, Tom, and I might be wrong, I've been saying this for years. I believe plenty of firms take the entire fee off the amount of the settlement or resolution and then take the costs. And if you can think about it that way, that firm that does this isn't bearing any of the costs. It all comes off of your end after they take their money. So that's one of the benefits. I mean, we've done this for years. Tom and I were actually at the same firm before Tom came over to work with me at Rate Law. And they did it that way since I started in the early 90s. And that is, you settle a case for $100,000 and there's $1,000 of costs. We take those costs back. We pay the firm back for those $1,000 right off the top. So now you're at 99, one third, 33,000 is the fee, 66 to you. But you can see if we did it the other way, that I believe some firms do, maybe a lot of firms for that matter, then you take the 100 and we get one third right off the 100. Then we take the 1,000 off of your portion. So we don't do it that way. And it's one benefit. But the truth is, the overall fee structure is of great benefit to our clients because, as Tom mentioned, it's a way to be able to pursue the claim. And there's very little, if any, risk to you, certainly in the way we take our fee. And then at the end of the case, you will receive from us with your check a breakdown letter that spells everything out. We thank you for your trust. We show you where the money went by putting the number one spot, the amount we settled for, then the costs involved. And if you want to see the cost, we have an itemization. We can show you the costs that were borne during your case. And, I just talked to a client today about it. There's a huge difference on average in the amount of the costs if we settle without filing a lawsuit versus settling within the lawsuit or at the end of the lawsuit or even going to trial when the costs tend to be the greatest. And I told this person generally, and about 75% of our cases, I believe, we settle without the need for a lawsuit. And on most of those cases, the costs don't even reach $1,000. It's usually fairly minor because we don't have to do the kind of work that we have to do once we get into a lawsuit to really prove your case. There's some cases where some discovery needed to be done to make sure we had a case, or we had to hire an expert to see if we could settle pre-suit. And then it gets up there a little bit. But on average, if we can settle before that lawsuit is filed, the costs are relatively minor. If we have to file a suit, however, then they can get up there. And either way, we take it after we take the costs, and we take our fee after those costs are taken back from our office. And that letter we give you, we call it the breakdown letter, will explain all that to you. And we like to share that with you before you commit to coming in and getting your check and all that. So if there's any questions, we can answer them beforehand, and certainly when we meet with you. Questions and answers to us are a huge part of what we do because that's how we gain your trust. And it's very nice, I would hope, for you to know that you can simply call us or you can simply reach out through an email and ask questions at any time, even if we haven't signed you as a client yet, because we know that the best way to gain your trust, whether it's before you sign or after you sign, is making sure we're there for you all on the way and answering your questions. Anything else, Tom, to add about how we do the fee
Yeah.
structures?
Yeah. And I want to build on that trust, right? And so trust is so very important. And obviously, trust is a two-way street. Yeah. We've had the prior podcast where we talked about how important it is for you to trust us, but also for us to trust you and make sure we're getting all the information from you. But here's one beautiful thing about contingency fee. Not only does it give access to justice to people who might not otherwise have that access, it's that it keeps our interests aligned, right? And what are those interests? To maximize the recovery for you. So if you talk to people who've hired attorneys on an hourly basis, they're inevitably going to tell you, right? No matter what, they're going to get back and they're like, man, this guy is taking forever. Or, holy smokes, I can't believe he billed me 30 minutes for that letter he sent out. I can't believe, right? So all of a sudden you start getting this feeling from these attorneys, not just attorneys, pretty much any service where you're paying by the hour. You're like, man, I feel like they're dragging it out to charge me more, right? That doesn't apply with our way of billing of the contingency fee basis, because I mean, think about it. We could spend 1,000 hours on a case, 2,000 hours on a case, and it's not going to change the amount of recovery that we would get, or it doesn't change the one third. It doesn't change any of that. So we want the case over as quickly as you do, right? And you want the case done quickly. So we're working on that. Our interests are aligned. We also want to maximize the value of your case, because how do we get paid more? I know a lot of people are thinking, like, how does that attorney get paid? Well, we only get paid when you get paid. We only get paid more if you get paid more. We only get paid quickly if you get paid quickly. There is not a single part of that equation or those equations where our interests aren't running exactly in the same direction together. And that's how we view all of these cases. It's you and I together. It's Bobby and you together. We're all working together for one like solidified goal, and that's to maximize your recovery.
I spend a lot of time, if it's not within our expertise of these various types of personal injury cases, referring people that, I met over the years to, whether it's a divorce attorney or a corporate attorney or a bankruptcy attorney. And I referred a good friend of mine to another good friend of mine who does divorce. And the divorce is over, and I called to congratulate him, putting it behind him, blah, blah. And he says to me, "This guy took me to the cleaners." I said, "Who?" He said, "This jerk that was your friend that you sent me to." I said, "What are you talking about?" He said, "He billed me for everybody that even looked at the file in his office." I said, "Did he bill it all at the same rate?" He said, "No, there's a bunch of different hourly rates," because that's what these firms do, because that's what they have to do. So the paralegal works on that hourly, case, and the secretary works on the hourly case, and the clerk works on the hourly case. So he got this bill, and everybody has their hourly rate, and then there's a total. And I told him, unfortunately, that's the way it is. That's just one of the terrible things about when you get divorced. But the truth is, we don't hear that because you don't know that. You don't know necessarily what we're doing. We're just doing a lot of work, so we're all happy in the end, so that our third is as much as possible, because your recovery is as much as possible, and it's nice that way.
Yeah, I mean, like I said, I love the fact that at no time can anyone say, "Hey, look, your interests are not aligned with your clients," right? Because we're always in line with everybody. But I get it. I get it. Understanding the contingency fee basis, and it's even a new word, right? How often do we use the word contingency fee in normal everyday speak? We never use it, so it can be confusing. But that's why we're always available to answer any questions for you. Right. So we have a toll free number, 866 rate law, RAITTLAW. Give us a call anytime to discuss, how we bill, how this contingency fee agreement, whether or not you have a case, or come to our website. Right. And our website has some great information. We're actually just revitalizing it right now. We're adding some more content. And that website is www.firstrate.law.com. And that's FIRSTRAITT law.com. And we're excited to hear from you. Yeah, don't forget to catch our next episode, because as fun as I thought, I thought number 8 was a really fun one. I mean, granted, number 9, you need to know about the fees and all this stuff, but it's not as sexy, right? This isn't as fun a topic. But our next episode 10, is going to have some harsh realities, right? Because you can't win every case, and so we're going to talk about some of those.
We don't like talking about it, but
I know. Well, you know what? I hate talking about the losses, but what I do like talking about is what we learn from those things, and that becomes important, right? It's always about growing, knowing, understanding, and then doing better for everybody.
That's true. Thank you.
Thank you, everyone.